Hey everyone, Harry here to talk about the reports of Trump's anticipated strategy when the case from the Supreme Court, which is, recall, his actual case, returns now to Judge Chutkan, which won't be for another month. There's a 25-day period under Supreme Court rules, and then another week till the piece of paper, a mandate, is actually in Judge Tanya Chutkan's hands again, and the case is there. Okay, the reports are no surprise, and we could have predicted them before, but it's basically Donald Trump is laying plans to resist any efforts by Jack Smith to use pretrial proceedings as a way to surface evidence in the case. So the idea here, and it's received a lot of play and a lot of enthusiasm. I think, the estimable Andrew Weissman had an op-ed the very day of the opinion saying they could do something like this mini hearing with the upshot that some of the evidence that could be so important in the trial that we will not get, nevertheless could be presented in a different context, the context of a mini hearing to decide in the application of the remand from the Supreme Court whether or not action in the indictment is official conduct and therefore immune, or unofficial conduct and therefore not immune. And it's certainly true that the Supreme Court contemplates in the opinion that Chutkan's very difficult, very cryptic task in the wake of the opinion will be a remand to try to sort through their guidance that is tangled and I think in some instances circular. We could talk about that at another time. But this prospect now, which has really been in the water, that once it goes back to Chutkan, we can get some important evidence from Mike Pence, from Mark Meadows, from Pat Cipollone, who would talk about the conversations, say, they had with Trump, not before a jury, but before a judge, so that the judge could make the determination, hey, what part of the indictment survives? I have always been bearish, I think is that term. There's bullish and bearish. I've always been dubious about these prospects, even though they are championed and even anticipated by colleagues of mine who are very prominent. I very much respect, but I think it's been sort of wishful thinking. And that's all the more so when you really delve into the Supreme Court opinion. Okay, why do I say that? So the opinion is not simply states this broad immunity principle that is very extensive, but it has additional kinds of traps for the unwary and sinkholes that I think really arm Trump to resist the idea of a mini hearing. One in particular is that the court, and this is where Justice Barrett parted company, but 5 members of the conservative majority said, you cannot consider evidence of official action or immune action in deciding whether a case can be brought for personal non-immune action. Now, a little aside, why did the court say that? Not very persuasive reasons. They, at least in their immunity, paean to immunity, that's the core of the opinion, gave all these bromides about the need for a nimble and aggressive presidency, and maybe a president, though it hasn't happened in 200 years, being cowed and chilled by the prospect of a criminal charges later. But that principle, it seems to me, does not apply to the prospect that an official action will be made public in a jury trial or whatever. I mean, most official actions are made public. There are doctrines there to protect ones that shouldn't be, like executive privilege or state secrets. So why the court had to impose that extra prophylaxis of you can't even discuss or have evidence about official conduct is, to me, I thought unpersuasive and threadbare. Okay, but why does that matter? Because now let's consider this proposal for a mini hearing. The parties get together, and it's now time to decide what happens on remand. Now, it's going to be Trump's position that this doesn't require any evidence, and so we know from this new reporting, and it's no surprise, his lawyers will fight at every turn the presentation of evidence. They'll say no, and they'll have real basis, by the way, in the opinion. The court's a little inconsistent, but they'll say, you're supposed to look at the allegations here. And based on the allegations, you decide whether it's official immune conduct or not. And so now Jack Smith comes forward, let's say, he endorses the mini trial. He tries to make it happen. He said, no, Your Honor, we're going to show you. The Supreme Court did say if it's a middle ground, you need to it's presumptively immune, but we can rebut the presumption, and you have to know the context. That's the term the court used, and to know that, we got to hear from Mike Pence, or the Department of Justice calls Mike Pence to the stand. That's the core, and now the mini trial advocates are like, great, now we're going to hear, and the American people will have it recorded, the dastardly criminal, he may be immune, but criminal conduct that Trump undertook. But I don't think so, because at that point, they stand up and say, wait a second, what Pence is about to talk about is immune conduct, or at least we assert it is, and you can't use it for that reason. So there's a certain circularity in the Supreme Court opinion, but I think they stand up and say, you're putting the cart before the horse. You need to decide, Judge Chutkan, if this is if what were maybe they give you a proffer of what they'll say, because if that's official conduct, you can't use it. And the court made clear that conversations between the president and vice president are by and large and overwhelmingly official. They leave a little room for Pence acting in his capacity as the head of the Senate or whatever. But I think they can force the issue and say, you need to decide. We maintain this is official action. You can't use it. And now what happens? They push for that to be decided. Let's say she decides against them. Said, I thought it over. Nope. And Mr. Smith, call your witness, the former vice president. At that point, this is an immunity issue. And that means there are interlocutory appeals. And it's, not if they're frivolous, but after the Supreme Court opinion, kind of nothing's frivolous. There's always an argument here. So I think at that point, Trump says, I appeal your determination that you can put on this evidence. This is against what the Supreme Court says. And I think it freezes things, goes up to the D.C. Circuit, and potentially even the Supreme Court, which, they've made a ruling for a party of one. And it won't be difficult for them to just sort of slap it down, as the D.C. Circuit itself would know. And that, of course, is just part and parcel of the whole immunity opinion. It's clear from the Trump strategy that's been reported, but would be really predictable, that he'll have other cards to play to try to keep the Mike Pences of the world from getting on the stand. For example, he apparently wants to raise a speech and debate, or have Pence raise it, or maybe have others invoke Fifth Amendment rights, John Eastman, for example. All of those strike me as quite secondary, but again, the game here for Trump is to prevent testimony from coming out of the sort that could have a, lesser but still vivid impact as an actual jury trial could. He well knows that that's the desire, if not of the DOJ, at certainly of so much of the country that was transfixed by the New York convictions. But the conduct here in the Chutkan courtroom really is just the core kind of malfeasance and constitutional betrayal that state an overwhelming case for his not becoming president. So it's one thing to have it on paper. It's another thing, and the fond hope of so many now that it's finally out of the clutches of the Supreme Court to have Mike Pence raise his right hand and talk about, Trump calling him the P word and badgering him and threatening his life and being indifferent, all those things. But the Supreme Court, I think, has armed Trump with many tools to be able to, run the table, which is really his only goal, right? We are now 4 months away. Is that, one trip up and down the courts? So I think even if he doesn't persuade Chutkan that she has to do, she can't immediately put Pence on the stand. He has other cards to play, all of which make me, as I said, glum and bearish about the prospect, for which I understand my colleagues' enthusiasm of getting some evidence out there at least of Trump's actual conduct and conversations. But the reports are clear now that, as I say, no surprise, he will try to parry that at every turn. And I'm just here to tell you that in my analysis and calculations, the Supreme Court really given him a lot of ammo to play with in that fairly limited goal of just keeping the testimony off the stand until the election. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.